All right, welcome back, everybody. We gave you a break right before this presentation because there's a lot to absorb here. And the following information is something, regardless of our age, we all need to think about. So thank you, Tracy Rowans from the Elder Law and Advocacy Center, for spending time with us today to talk with us about what we need to do to avoid personally being subject to a guardianship or a conservatorship.
Okay, well, thank you for the introduction, and let me just start with the title, which is also sound advice. Speak for yourself. Avoid guardianships and conservatorships. So that's a great piece of advice, I happen to think, but it's true that in order to act on it, you're going to need to know how do you speak for yourself and why is it beneficial to you and your loved ones to avoid guardianships and conservatorships. Next. So I am Tracy Rowans, as Catherine introduced me. And I do work at the Elder Law and Advocacy Center, which is a legal services organization that provides legal services to residents of Wayne County who are 60 years of older and their caregivers for no cost. And the reason I'm talking to you today about guardianships and conservatorships is because at my office, we focus solely on the unique legal issues and challenges that affect older adults. Now, we're able to do this because we're a nonprofit organization, and we exist thanks to our funders, the Area Agency on Aging 1A, 1B, and 1C, the Older Americans Act and the Older Michiganians Act, as well as the Charter Township of Canton CBDG program. Now, let's get right to it. Since I've been working in elder law, I've noticed that there is a general misconception that most of us think that if something happens to us and we're unable to make decisions for ourselves, that our friends or our family members will be able to step in and assist us with our financial and healthcare decisions. But unfortunately, that is not the case. In order for a person to act on behalf of another person, they must have been given legal authority to do so by another person. And that can either happen through legal documents or through an order of the probate court. So I want to begin talking about why you want to avoid guardianships and conservatorships by providing the next 3 points, all right? So number 1, guardianships and conservatorships are judicial safety nets to protect vulnerable adults. That's why they exist, specifically, to help those individuals who are unable to manage their healthcare or finances. They do not have families or safe support systems. And without the appointment of a court-ordered guardian or conservator, are at risk of abuse, neglect, or exploitation. Next point, guardianship and conservatorships can be avoided. There are alternatives in the form of legal documents that are readily available, that allow us to legally determine who and how we want to be cared for if and when we're unable to do so ourselves. Last point, guardianship and conservatorships are intended to be avoided, but many of us who do have family who's willing to assist are either unaware of the need to formalize their wishes, or they're unfamiliar with the alternatives, how to formalize their wishes, or they just put it off. And alas, by the time an individual is unable to make medical and healthcare decisions for themselves, it might be too late to take advantage of the alternatives, and a court-ordered guardianship or conservatorship is going to be the only option for family members and friends to receive the legal authority to assist their loved ones or friends. Next. Okay, so now that you have that point of reference, in order to explain why you want to avoid guardianships and conservatorships, you need to know what you're avoiding. And then I'm going to cover how to avoid guardianships and conservatorships and the alternatives. Now, because I'm going through a lot of information, as Catherine hinted, here's a little roadmap, all right? First, I'm going to talk about what's the purpose of guardianships and conservatorships. Second, what's the criteria for appointment? Third, what's the process? How does it work? Fourth, some insider reasons why guardianships and conservatorships should really be considered a last resort. Fifth, the how to avoid guardianship. And finally, sixth, I'm going to go through the alternatives for you. Next slide. So what is the purpose of a guardianship or conservatorship? The purpose is for the court to appoint a person to legally act on behalf of another person. A guardianship or a guardian is tasked with the legal authority to make the medical treatment and residential placement decisions for an individual. A conservatorship appoints a conservator who has the legal authority to manage and preserve assets, including all of the individual's financial accounts and real estate. Next. Number two, what's the criteria? So the criteria for the appointment of a guardian or conservator is that the petitioner should provide evidence that the subject of the petition, the person who's subject to the petition, is by reason of mental illness, mental deficiency, physical illness, disability, or chronic intoxication or chronic drug use, that individual is an incapacitated individual. By incapacitated individual, I mean they are unable to communicate informed consent, and therefore they require the appointment of a guardian. Now, in the case of a conservator, the petitioner has to provide evidence to the court that the subject of the petition, again, by reason of mental illness, mental deficiency, physical illness, disability, or chronic intoxication or chronic drug use, is a person who's in need of protection. And that means that that individual is unable to manage their property and affairs effectively. And they have assets that without proper management will be lost without the appointment of a court-appointed conservator. Next slide. So what's the process? Well, like any good court process, it starts with a petition or petitions if the person requires both a guardianship and a conservatorship. And the petitions are appropriate in the probate court where the individual resides or owns property. And the other requirement is that the petitioner must pay the associated filing fee and document fees. The petitioner, who can that be, you ask? Well, it can be family members, it can be friends, it's anyone who wishes to be appointed as the fiduciary for another person. But it can also be representatives of hospitals or adult protective services who have identified a vulnerable adult who requires the appointment of a professional fiduciary. Once the petition has been filed, the next step is the court will set a hearing and appoint a guardian ad litem. And the guardian ad litem is a representative of the court who is responsible for meeting with and advising the person who is the subject of the petition of their rights. And then, after meeting with this individual, preparing a report that contains the relevant facts for the judge to review prior to the hearing. The judge alone is going to make the decision whether it's appropriate to appoint a fiduciary. If the judge finds that the criteria for the appointment of either a guardianship or a conservatorship is met, then they're going to issue, respectively, either the letters of guardianship or the letters of conservatorship, or both, if both are in play. And these are the documents that the actual physical legal document that evidences that the court has appointed this individual to legally act on behalf of another person. And copies of this document need to be provided to the individuals or organizations who need to rely on it, like hospitals, doctors, bankers, financial planners, etc. And one last thing, it's always possible that the judge, based on the evidence or lack thereof that's provided to the court, will find that it's not appropriate to appoint a fiduciary for the individual subject to the petition. They have capacity. They're not individuals in need of protection. And the court's going to dismiss the case. Next. Now, why should guardianships and conservatorships be considered a last resort? The insider view that these things may not be apparent to those of you out there. Number one, it's the law, all right? A court cannot, a guardianship or a conservatorship cannot be imposed on an individual if there is a lesser restrictive alternative available. I might need a little drink. Yep. And yes, those are the very same alternatives that I'm going to discuss with you in just a minute. Another reason why you definitely, if you can, avoid these processes is that the individual who has now been appointed a guardian or a conservator, well, that person becomes a ward of the court. That individual loses their independence, they're stripped of their rights, and they can no longer make any decisions of their own. And they're not the only ones who become a part of the court process. The fiduciaries who are appointed are responsible to the court for mandatory court process. And this can include, for instance, guardians have to file a report regarding the condition of their ward each year in order to update the letters of authority. Conservators have to file a detailed accounting of their ward's assets annually, again, to update the letters of their conservatorship. And also, every 3 years, they have to present that accounting in person at a hearing with a judge. Things can get even more complex. They can be delayed. Hearings mean more cost and potentially more filings for direction that can only be provided from the court. And next slide. The petitions can be contested, all right? So there can be contests. There's no guarantee that the petitioner is going to be appointed. The person subject to the petition has the right to contest. Siblings, if there are multiple siblings of the petitioner, they have equal right to act as a petitioner for an individual. So they can, if they don't unanimously support the petitioner, they can take sides, they can object. And what can happen, what happens a lot, unfortunately, is that family members will object and things will get more complex. Petitioner will hire an attorney, the objecting family members will hire an attorney. This causes not only delay, but a real increase in costs. And because of the delay, the judge is going to appoint a temporary professional guardian or a conservator to act on behalf of the subject of the petition. Ultimately, the judge is going to decide whether the appointment of the guardian, the conservator, is appropriate. But they may decide that the best interest of the individual who requires protection or is an incapacitated individual, that the best appointment would be a neutral professional guardian or conservator. This happens, and my experience in situations like this is no one is ever satisfied with the outcome. And one last reason to avoid guardianships, to plan for something other than a guardianship, is even though courts act in a vulnerable adult's best interest, and they're very careful that they do so, it's possible that if there's no objection or if there's no evidence contrary to the fact, a seemingly caring or competent bad actor can be appointed as the fiduciary for a vulnerable individual. And this can lead to abuse. This is abuse, especially in an economic downturn or say during a pandemic. Bad actors may seek to exploit an older adult who owns their own home, who receives a social security check every month and a pension. And the subject of the petition may be too frightened to speak against the petitioner. They may feel that they have no options. They do need someone to help them, and well, the devil they know. Next slide. Okay, you have the picture. Guardianships should be avoided. Conservatorships should be avoided. Now, let's focus on what does a person need to do this? First, forethought and desire. A desire to never be or never need a guardian or a conservator. Second, they need the knowledge of the alternatives. And third, they must have the ability to understand and communicate informed decisions. Why? Because that is the definition of legal capacity, and it is required to execute the legal documents I'm about to discuss. A person has to be able to have sufficient capacity to understand and communicate the nature and effect of the act in which the person is engaged. That means they must reasonably understand the choices that they face, as well as the risks and benefits, and be able to communicate their wishes as to those risks and benefits. And they have to be able to sign that document voluntarily. No undue influence. An important note. Older adults who have capacity are entitled to make decisions that family members and physicians do not agree with. They have the right to make bad decisions, just like everyone else. oops, excuse me. In older adults, capacity can be slippery. It can fluctuate. It can be affected by time of day, medication, hearing loss, memory loss, or even grieving. But you need to know that a diagnosis of early dementia is not evidence of a lack of legal capacity. If capacity is questionable, an attorney should meet with an individual for a legal capacity assessment. An attorney may meet with an individual on multiple occasions because a person may have lucid moments where legal capacity exists. And if there is capacity is particularly at question, an attorney may recommend that an individual be evaluated by a neurogeriatric psychiatrist or psychologist. Okay, so we are on to the alternatives. We've arrived. Now, some of these, I've listed them for you. You're going to be familiar with the names, possibly, okay? But I'm going to go through them one at a time so that I can highlight some of the specific benefits and why you want them. I'm going to talk about the durable power of attorney for finance, the durable power of attorney for healthcare, which, spoiler alert, this document is known by 3 names. It's also known as a patient advocate designation, a PAD, or as an advance directive. So even though they have different names, the document has the same legal intent, and you really only need one, okay? I'm going to talk about HIPAA releases, trusts, supportive decision-making, living wills, and the My Post form. Next slide. First up is the powerhouse. They are the powers of attorney. Elder law and probate attorneys, medical providers all agree that everyone over 18 should have powers of attorney. Why? Because powers of attorney are legal documents that allow us to authorize a trusted person to to legally act on our behalf while we're alive. The legal authority terminates at the owner of the document's death. And the power of attorney for finance, I just want to let you know that the party's name or the players involved are the principal, who's the owner of the document, and they appoint an agent. And under a power of attorney for healthcare, also patient advocate designation or advance directive, this is where the owner of the document is referred to the patient and they appoint an advocate. And what are the benefits? Well, immediately out the door, this is a private document. There is no court involvement. They don't have to be filed, they're private. The owner of the document dictates the level of the reporting required, if any, by their agent. And the choice of agent or advocate is the principal or the patient's decision alone. The other very important thing about these documents is that you are not locked in by your document. The principal can revoke the document and can fire their agent. Even if the owner of the document doesn't have legal capacity, they still have the right to fire their agent or advocate. However, they cannot redraft their documents. And that's why it's particularly important that owners of these documents appoint not only a primary agent or advocate, but also contingent agent and advocate. So if a primary agent is no longer able to act or is fired, there's a seamless transition to a contingent agent. And this brings up the important, I know it's last, but it's not the least important, the importance of your choice of agent. Because legal authority of any kind can be abused, your agent or your advocate must be someone that you trust with your life, someone who you have thought about, who is responsible and capable of the tasks that are going to be required of them, and someone who understands your values. Next. So I'm going to look at these documents, and I might go through them a little bit quicker. We're going to individually look at the durable power of an attorney for finance. I want you to know that the agent has the same authority that the principal has, or would if they had capacity. I want you to know that the agent manages all the finances in the name of the individual, securities, bank accounts, retirement accounts, as well as the individual's real estate, which they can sell, lease, mortgage. They have carte blanche, unless the principal wants to restrict their authority, which the agent, which the principal can do. And because the document is so flexible and meant to be personalized, individuals should meet with an attorney to draft their durable power of attorney for finance, so that the document will address not only the specific assets of the principal or the agent's authority, but anticipate the principal's future financial needs and concerns. The document will protect both the principal and the agent. The agents under a durable power of attorney for finance are held to a fiduciary standard. That means they have to manage the assets in the best interest of the principal. And at the same time, the document protects the agent, because agents are not individually liable for the principal's debt or bad decisions. So when is a durable power of attorney for finance effective? Well, again, it's up to the principal. The document can be either drafted so that the agent has immediate authority to act, even while the principal has capacity, or the document can be drafted so that the agent's authority only springs into effect, known as springing, upon the principal's or the patient's incapacity. Nope. Now I really am tripping. This is true of both the durable power of attorney for finance and the durable power of attorney for healthcare. So springs into action at the principal's incapacity, at which time the agent must present 2 letters from 2 separate physicians, or a physician and a psychiatrist or psychologist, that state that the principal is no longer able to communicate informed consents that third parties can rely on. Now, quickly, just a few things specifically about durable power of attorney for healthcare. The advocate, who's appointed by the patient, makes the medical treatment, also the residential placement, and the end-of-life decisions. And it reflects the patient's values and wishes. The document can specify what procedures and treatments that patient would want or that they would never want, and can also authorize their agent to make end-of-life decisions that are based solely on their advocate's judgment or upon input from a specific physician. It also allows the principal to authorize their advocate to make mental health treatment decisions, which now in Michigan has to be specifically authorized for the agent or the advocate to act. So what you want to remember about a durable power of attorney for healthcare is that, unlike a durable power of attorney for finance, this document is only active. The agent only has legal authority to act when the patient is no longer able to participate in medical treatment decisions for themselves or as determined by two physicians or a physician and a psychologist. All right, we're moving on. Next. HIPAA release. Many of us are familiar with this document, or at least we've heard HIPAA often enough. This HIPAA release, or the authorization to disclose protected health information, is a legal document that authorizes a patient to share personal health information or have access to personal health information with a trusted person or a third party. And, you know, the HIPAA Act, which is the Health Insurance Portability and Accountability Act, what that does is it guarantees that we have a right to our personal medical records, and we also have the right to determine how any of our personal healthcare information is shared with other healthcare plans, doctors, hospitals, and other medical healthcare providers. The point to remember about this document, what's unique, is that it is immediately effective upon the patient's signature. And why is that important? Because, as I just explained, under durable powers of attorney for healthcare, your agent cannot act on your behalf until the patient no longer has capacity. But what if the patient has capacity, but they're not mobile, right? They can't get out and pick up the MRI films that their neurologist needs to review ASAP, or pick up their medical file, which also, if that isn't taken directly to another physician, you know, it could impact that patient's ability to receive care. So what do? Well, under a authorized HIPAA release, the patient is able to identify individuals who they trust, who it is appropriate for the persons who receive a copy of the HIPAA release or authorization. They're authorized to release the patient's personal information to them. So yes, if I'm on Catherine's, you know, HIPAA release, she needs me to pick up documents. Zoom, she has capacity. Trust me, she has capacity. But she wants me to pick up those documents. I'm there. I've got it. And the physician who requires them can quickly have access to them. I want to add that in addition to powers of attorney, HIPAA releases should be a go-to. You should include that. And when you talk to an attorney, have them draft one for you, okay? Next. Okay, so now we have arrived at trusts. Remember that I said that everyone, because I just said it, everyone over 18 needs powers of attorney, and that's still true. And I've added the HIPAA, still true. But when it comes to trust, maybe everybody doesn't require a trust. Maybe they won't benefit from having a trust. In a trust, and trusts get a little bit more complex, so I'm just going to go through the basics. In a trust, the owner of the trust is known as the grantor, and the grantor authorizes an individual who they trust, also known as the grantor, excuse me, as the trustee, but the trustee can be the grantor. Hold that thought for a moment. And also a successor trustee are appointed in this trust. And that authorizes these individuals to manage the assets that are specifically titled in the trust. Okay, so not your bank accounts that your agent under your financial power of attorney can access, but these are bank accounts in the name of the Tracy Rowan's Revocable Trust. So only the trustee of that trust or the successor trustee is going to be able to act on those assets. And what's the purpose of a trust? What is special about them? It's because that trustee and the trust is the trustee has the authority to act on the trust assets during not only the grantor's lifetime, but also after the grantor's death. So it is a way to manage assets while someone's alive and, if necessary, distribute in a more flexible manner than is possible with a last will and testament. Now, I'm going to touch on just quickly two kinds of trusts that you may have heard of, you may be familiar with. And one of them is a revocable trust. Okay, and again, it's popular for its flexibility. And why is it revocable? Because that trustee, who is either a grantor or someone who the grantor has appointed, can manage the assets that are in the trust for the benefit of the grantor during their lifetime and after. That is what is unique, okay? And the other interesting thing about a trust is that a trust assets avoid probate. Now, there are other ways to avoid probate, but trusts definitely do that. And they allow the grantor to distribute their assets, unlike under a last will and testament, where assets are distributed as soon as possible after a probate has been opened and the personal representative has legal authority to distribute those assets. But the personal representative's task is to distribute them outright to the individuals named as quickly as reasonably possible after the death of the individual. A trust, on the other hand, there's much more flexibility. The grantor can decide that at his death that assets are held in trust for the benefit of someone, or that if they have individuals who may or may not be, in the grantor's opinion, capable of handling an outright distribution. Distributions can be in phases, all right? Distribute a percentage every 5 years, etc. That is why trusts are known as flexible documents. There's more things that can be done with them. And I am going to, quickly discuss one trust that people should know about. And this is a special needs trust. And I'm going to give you an example. There are other reasons for a special needs trust, but this one I think people will understand quickly. So if I'm a disabled individual and I'm receiving SSI or Medicaid benefits, and I'm under the age of 65, what happens if I receive an inheritance of $200,000? Well, I can tell you I'm going to get kicked off my benefits really quickly. And an alternative to that is that the disabled individual, if they have capacity, or the parent, a grandparent, or a guardian of a special needs individual, can establish a special needs trust. And what happens there is a trustee is appointed, someone other than the disabled individual. And that person is able to manage the assets in that trust during the life of the disabled individual. They're able to use those benefits for the benefit of that individual, and the government benefits are not affected. Okay, and there are rules that are specific to how these distributions are made. And there's also rules about how a special needs trust is distributed after the individual's death. So I want you to know about this trust because it can be very helpful. And if you know people who are trying to plan for disabled adult children, this might be something that will be helpful. Okay, trusts, again, you need to discuss these with an attorney. There are too many different kinds of them, and you may or may not need them. But what you will need to know is that when you have a trust, they play well with powers of attorney. You need to have both, all right? And often what happens is that if you meet with an attorney and you are someone who it's really appropriate to have trust, they're going to, meaning an elder law or a probate attorney, they're going to prepare what's known as an estate plan, okay? And a trust is just one piece of the estate plan. The estate plan is going to include durable powers of attorney, a pour-over will, HIPAA release, and possibly a few other documents. And this, so what I'm trying to get here is that don't be surprised if you go to talk to somebody about a trust and all of a sudden you're into a more elaborate collection of documents. That's what's appropriate and that's what's necessary when you have trusts, if you need a trust. So talk to an attorney, discuss your specific assets and the plans about how you choose to live your life and your distribution wishes after you're gone. Next, supportive decision making. Just like any adult over 18, adults with intellectual and developmental disabilities have the right to make their own healthcare and financial decisions. And just like aging adults, we need to presume capacity as a starting point. We all have the right to make our own decisions if we have capacity. So supportive decision-making is a tool that can be used with or without a durable power of attorney for healthcare or finances. And what this does, it's a process that includes discussion with the family member and allies that allows the individuals to understand the import and the effect of their decisions. Their family members can help point out risks, the advantages, and the consequences of what the intellectual developmental disabled individual is facing, and allow that person to participate and to make those decisions with assistance, but for themselves. Now, for information regarding supportive decision making, and I apologize that I don't have phone numbers, but the organizations that you want to contact are either the Michigan Alliance for Families, and if you smoosh that all together and put a .org after it, that's going to be the website where you're going to be able to get this information. Again, it's Michigan Alliance for Families. And the ARCs of Michigan, and that is arcmi.org. Okay, terrific resources for information. And yes, I am on the next slide. And the next slide is a very specific document that allows an individual to specify their medical end-of-life treatment requests. And although in 47 states, living wills are legal documents, here in Michigan, not legal. But the reason you want it, because it is still a very persuasive statement of the patient's intent, and it can be considered by physicians, hospitals, and the probate court. Living wills really do, after they're executed, need to be distributed to your physicians, your hospital. So in the event that something happens to you, that document is there. Your words are there to inform your medical treatment. The other reason these documents are helpful is, thus far, powers of attorney, trust, these are documents that allow us to appoint a surrogate, someone else, to act on our part, make decisions for us. But if you're a person who is very independent, or you don't have people necessarily who you trust, and you need to trust these people if you're going to give them legal authority, then you may want to just have this document to represent your wishes and your wishes only. It can be used, it's sometimes helpful when there is a durable power of attorney in play, when there is a patient advocate, because sometimes patient advocates have a difficult time making the emotional decisions that are contained within the patient's documents. So is it easier to provide a physician with your mother's wishes that are contained in a living will than to have to verbally say, she doesn't want resuscitation? Sometimes that's a hard thing to do, and having the living will there can make that agent feel more confident, or make it an easier transition to communicate the patient's wishes as they wished. Next slide. So the last document I'm going to talk about today is akin to the living will, except this is a legal document. And what this document does is it allows an individual, and we'll discuss who that individual is in a second, allows them to meet with a doctor and to specify end-of-life treatment in a legal document that is also a medical order. This type of document is intended for people who have no prognosis. I mean, their illness, they will succumb to their illness within a year. And for those people, they may be going up and back from a hospital, and they may be, they may want their specific care choices to be known by the EMT who's called when they're in distress. And this document, it's intended to be a conversation when the patient has capacity, or if the patient no longer has capacity, for the patient's advocate or the guardian who's responsible for their care, to be able to discuss and make plans that will be followed no matter what in the event of a crisis. And the two points or the two things that are unique to this document is that it discusses or it forces the patient or the, and forces too strong a word, it allows the patient to decide, do I want CPR? If my heart stops and I stop breathing, do I want to be resuscitated? And right there in this document, there's a yes and there is a no. And there's also the choice that if the individual is having labored breathing, but their breathing hasn't stopped, labored breathing, what type of care do they want? Do they want comfort care, which is palliative, just to make the person comfortable until nature takes its course? Or, are they going to want selective treatment that wouldn't go as far as something invasive like a mechanical ventilation, but they have that opportunity to select that choice. And the third choice is always full treatment. Prolong my life, no matter what. So this is a document, again, it's for people who have limited time, and there may be a call to an EMT, and that EMT will have the authority to act pursuant to the patient's wishes if this document is with them. Okay, and a copy of this document goes into the medical record and is also always with the patient, okay, whether they have capacity or not. So those are the alternatives. And now you know what is available. So once again, I ask you, what do we need in order to avoid guardianships and conservatorships? Well, we need to speak for ourselves. We need to reach out to elder law attorneys or probate attorneys or estate planning attorneys to discuss the planning alternatives that are the best fit for the individual. And it may be you, it may be a family member. You need to discuss this information so that if your family members are interested, they too could execute documents for themselves. Because remember, if we don't make decisions ourselves, the court will. So I thank you very much. That is my presentation for the day. I want to take questions if there's time.
Yes, so one of the questions we had was, in the case of an individual with complex medical conditions, how do you know, or what is the threshold for determining whether their medical needs are being met? And this question was asked in the context of the slides about guardianship. So really, how do you know if a person needs a guardian as opposed to whether they're capable of taking care of their medical needs without a guardian?
Well, that's actually a very involved answer, but let me just touch on it. If the individual is suffering as a result of lack of care or self-neglect, and they are unable to manage their health care appropriately, that may rise, to a level where if they do not have, if this individual is assessed and they do not have capacity, that that it would be appropriate for someone to petition the court for a guardianship, but only if they don't have capacity. Because remember what I said, and this is true, and it's a fine line, so you really have to look at all the facts. An individual, an older adult, any one of us, we're entitled to make bad decisions. We're entitled to make decisions for ourselves. And if we have the capacity to explain while we're making these decisions, then that individual, you know, doesn't require a guardian. And, you know, you can discuss with them having documents drafted for them where an individual would be able to assist them and talk to them about their wishes. But that's a you know, that's a difficult area, and you have to approach it, you know, first from capacity, because that individual has rights.
And we also have a few questions about raising concerns with probate courts and how guardianship matters were handled. One of the questions, the poster indicated that a relative of theirs was placed under a guardianship under circumstances in which the court considered that guardianship as the first alternative, and other alternatives were not considered before placing that person under the guardianship. What options does that person have if they're concerned about their relative being placed in that guardianship?
Well, there's an immediate appeal that can, you can appeal the decision. The other thing is petition to modify. There's alternatives there. So if they are unhappy, who was appointed as the guardian in this case? Do we know? We don't know. So
no, that wasn't indicated. The concern, I believe, is more that a guardian was appointed when the person is indicating that perhaps that wasn't necessary.
And again, the ward themselves, if they have capacity, can raise this issue and ask for the guardianship to be terminated. They can either write a letter to the judge or actually file a petition. They're entitled to address this. And, you know, depending on the facts, you know, they might have an appeal, but without more information, I'm not comfortable giving specific information. So I would ask that person to, you know, look into this and contact an attorney, or have the individual, if they have capacity, speak with an attorney. Okay.
And then along similar lines, a question about the same guardianship was that in that matter, the guardian has not shown documents to indicate what has been done with the ward's money. So this person is indicating that a few years ago, multiple thousands of dollars came up missing, and to date, the guardian has provided no evidence to indicate what has happened to the money. What suggestions would you have?
Who is the speaker? Is the speaker the individual themselves? Is the questioner? It is someone speaking for?
The speaker is a relative of the person who's in guardianship.
So if that speaker is concerned, they can appeal, not appeal, but they can petition to modify or petition to alert the court that the current guardian is mismanaging, and it's appropriate to either terminate the guardianship or to appoint another more appropriate. Now, you're crossing two different fiduciary appointments, though, because remember that under a guardianship, that allows an individual authority over medical and healthcare, residential placement, and it is a conservatorship if there are assets. So if this individual had significant assets, and I'm not sure they did because this individual is not discussing a conservatorship, it is appropriate if there are assets, if there is allegations of something inappropriate, to petition the court, let the court know, make the court review it, review the accountings. So there are things that can be done, and in those instances, you know, I would contact an attorney and with these specific facts, find out what is the most appropriate venue.
Thank you, Tracy. And I need to jump in here to keep us on time. Our time is expired, but I do want to mention to this person who asked the question, our task force has put forth some legislation to address these issues. The financial threshold is set here. This person asking the question indicated it was $300,000. In those circumstances, we would require a conservatorship that would require yearly reports. If it was under our threshold, the guardian should keep and make available, this is under our legislation, make available financial documents upon request of an interested person. So great questions. Very nice job, Tracy.